Target is one of the most recognized brands, one of America's leading retailers, as the 8th largest retail chain in the U.S., with over 350,000 employees in the U.S. and abroad, and with more than 1,900 locations in all 50 states and Washington, D.C. In 2021, their revenues were approximately $106 billion, and profits almost $7 billion. Their brand recognition ranked 14th in an esteemed list of well-known companies, even beating out companies like Ford, Home Depot, J.P. Morgan Chase, and General Motors. But Glassdoor and Indeed employee reviews rank Target as one of the worst companies to work for in America, which explains why Target has been the target of multiple lawsuits by employees and former employees over the years. In fact, Target has agreed to settlements by several California prosecutors of false advertising, commonly known as bait and switch. In this new insider-exclusive Justice in America network TV special, our news team sits down with Ron Podboy in Denver, Colorado, to go behind the headlines in this landmark Colorado employment case, Hoyt versus Target. In Justice in America, Target's Hall of Shame, which established new law to protect all workers in the state and to discuss the specific legal challenges and strategies to win the case. Ron will explain the major significance of the case because the issue involved was the right of employees to be duly compensated by an employer under the Colorado Wage Claim Act for time actually worked, which has been acknowledged to be an issue of major public and economic importance in Colorado. Ron successfully won a verdict for his client Susan Hoyt of $200,000 in compensatory damages and $35,000 in punitive damages for wrongful discharge in violation of public policy, and $15,000 in compensatory damages for breach of express covenant of good faith and fair dealing. Ron has earned a reputation as an unyielding trial lawyer who repeatedly represents individuals and families against big companies and the Goliaths of the world, and repeatedly wins. Ron has built a substantial reputation nationwide by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Denver, Colorado. It is my great privilege to introduce Ron Podboy to the show. Welcome to the show again, Ron.
Thank you very much, Steve. Good to be here with you.
Tell our audience a little bit about your firm. What type of law does your firm practice?
My firm is a trial practice firm. I like to say I enter the courtroom through a lot of doors. Criminal, personal injury, wrongful death, importantly in this case, employment law.
Okay, and the reason we're here today is we're going to be talking about it's a landmark case in the state of Colorado on employment, right?
That's true.
Hoyt versus Target stores, correct? Tell our audience a little bit about who was Susan Hoyt.
Susan Hoyt had worked for 13 years for Target. Always got great reviews. You know, companies like that are always doing annual reviews. She always got great score. Until a new supervisor came in, started to be downgraded. Susan was hardworking, honest, and really a great employee.
And why did she end up suing Target?
Target really messed her over. At trial, we were able to introduce evidence that Target was doing funny stuff with hourly pay. One of those things was called what Target liked to call pushing hours ahead. In other words, you had more hours in a week as a normal work week. You should be paid overtime. It's time and a half. Employers don't want to pay time and a half. Target would encourage their employees to put hours into the next week to avoid that time and a half. Is that legal? Not really. Another thing that was going on with Susan Hoyt was she was asked to go to store A.
On company business.
Yeah, she had to show up, punch and report to store A, but they didn't want to pay her till she got to the other store, store B, where she began work. And that was a big issue in this case.
That time accumulated. She was not getting paid for the time, which was travel while on the job.
And one of the things she did was she dealt with time cards. And what she did was put down her accurate time. She was fired. The company said that she was exercising fraud in order to be paid more and illegally altering a time card.
Even though she was telling the truth.
She's telling the truth. She put down the proper time.
In the state of Colorado, there is a Colorado Wage Claim Act. Tell our audience what that is.
Basically, you can bring an action under the Wage Claim Act if you have recorded hours and are not being paid those hours. This became a very interesting issue in the case. One of the things that Target stores said on appeal was, she had to claim under the Wage Claim Act and didn't claim under the Wage Claim Act. She simply brought a common law claim for her wages. Now, there was a catch-22 there. If there are no wages assigned to you, you can't claim against them. So she couldn't have done that. The Court of Appeals recognized that would have been an exercise in futility. And the Court of Appeals very importantly said she had an independent claim under the common law for her wages.
So the fact that Target claimed that she didn't earn this extra money, they also said it was hypocritical for her to bring a claim under the Colorado Wage Claim Act since she wasn't owed any money in the first place.
Well, they said she should have gone that way. And as I noted, the Court of Appeals said that would be an exercise in futility. Target was claiming she had no wages coming at all.
Okay, this case went to the Court of Appeals, but it was new law because of this case. What is the new law that it established?
Well, it had been established under a case called Crawford that people were allowed to get breaks, okay? This was more important in terms of public policy because it had to do with, are you going to get paid for the time you spent doing something for the company? Not just having a break, but actually, showing up in one spot, traveling for 45 minutes, an hour and a half to another spot, but they didn't want to pay you for that. So you weren't going from store A to store B for the fun of it or because you'd like to. You were doing it because you were ordered to do that by the company. That's called work.
And they recognized that. What was the result of the case?
Target really defended this case vigorously. At trial, they brought in a vice president flew her in from Chicago in order to give the company position. They hired a big law firm, Faegre and Benson in Denver. They just did everything they could to defend this. And on appeal, they threw pasta against the wall time and time again to see what would stick. Essentially, on appeal, Susan Hoyt won everything except one thing. She was given $15,000 by the jury, in addition to the $200,000 which she was awarded, which accrued before the case got to trial, and in addition to the punitive damages, which were allowed because the jury found that Target stores acted with wanton disregard and or malice in dealing with her. They also awarded her $15,000 because of a breach of contract of fair dealing. The appeals court said the testimony by Target stores, which was essentially the HR department coming in and saying, we try to be fair to everyone. And if you're fair to everyone, everything follows and everyone is treated equitably. They found that those statements by HR were not sufficient to form a contract. So that one claim was denied. Everything else, Susan Hoyt prevailed on.
Well, congratulations on the result of that.
Thank you. Let me note that one of the biggest issues in the case was Target stores fired her for what they said was illegally changing her time card. Okay. We were able to establish at trial that Target stores, one, asked her to do something that was illegal, two, that it was an important public policy issue, being paid for the work that you do. Three, that she was fired in retaliation for not doing what they asked her. And four, Target knew or should have known that what they were asking her to do was illegal.
Again, congratulations. We have with us your Director of Client Communications, Bridget Podboy. So we're going to bring her on right now. It's my great pleasure to introduce Bridget Podboy to the show. Welcome to the show.
Thank you for having me here.
Bridget, you are the support staff here at the law firm, correct?
That is correct, Steve.
Walk us through when a new client comes into the office and you have to support, the team. What do you have to do depending on the kind of case?
Well, Steve, first of all, my husband has to listen to the clients, and then we do our investigations. After the investigations, my husband does, he talks to the other attorneys that's involved with the other party. And if it's some kind of settlement or something we can do in between that, my husband tries to do that first. Other than that, he'll take it to court. And once we do our investigations, then we find out if it needs to go to court, that's where we take it.
Yeah, now some of these cases take a long time, like the case that we were talking about recently, took 8 months to get to trial. During that time, clients were constantly, calling in, right? And they want to know an update. And so you kind of provide an emotional backdrop for them, right? Support system.
That's exactly right, Steve.
Can you give me some examples of some of the cases? You don't have to mention their names or anything, where you really were of great assistance to the clients.
Well, Steve, first of all, when the client comes into the office, they're already, hysterical or upset for being there, number one. And to take it to another level and take it to trial, it takes it to a whole different level. So at that point in time, I have to be there for the clients, listen to the clients, especially when we have to take it to trial. That takes it to a whole new level. And so when we're in trial, my husband has to listen and focus on what's going on in the trials. Of course, there are many questions for the client, many questions that they want to ask my husband during the trials, the clients, the family members, everybody. And so my husband has to pay close attention to what's going on in the trial. And then I take notes, for instance, and I give them to my husband and alert him that, these people are concerned about this or they're concerned about that. And as far as, just little things, just reassuring them, hugs, talking to them, just listening, most of all. And clients appreciate that. But I have to be there more for them because Mr. Podboy can't do that when he's in trial.
So what is your opinion of the justice system today?
My opinion of the justice system can kind of go different ways with different trials. But I can reassure you that my husband makes sure that he knows that everybody's going to be treated equal during a trial. If it doesn't go to trial, he's going to make sure all of his clients are being treated equal.
Well, you apparently are doing a really good job because he's winning cases. So I want to thank you very much for being on the show.
Well, thank you so much, Stephen. He is winning lots of cases.
Right, and being part of Team Podboy, right?
Team Podboy it is.
What is considered being wrongfully terminated?
It's tough in Colorado. Here's why. Colorado is a right-to-work state. That means you can be fired for any reason or no reason, as long as it's not an illegal reason. We established in this case another illegal reason, which was the situation where she was ordered not to report a period of time where she actually worked. So it expanded the workers' rights under Colorado's right-to-work law.
Okay, and what if you're fired for retaliation?
If you are fired and you have a valid claim for something and you are fired in retaliation, this can happen in state court, federal court, trials. You have to prove that the retaliation was what got you fired. That can be hard to do. Sometimes performance reports that are favorable to you disappear. And they say, well, you were not just a good worker for a long period of time. Hey, that's why you were fired. Well, it was not because you went to HR and talked about sexual impropriety by the boss or something like that. We just fired you because you weren't a good employee. And so you've got, in that situation, you have to prove the retaliation was what you got you canned.
Because of this case, and it was a landmark case, you have a lot of people contact you regarding employment cases. How do you decide which ones to take?
I'll tell you, in Colorado, it's tough. I always say you look at 70 cases before you can take one. A lot of people think they have a case in employment, but the law here is really canted towards the employer. With language like you can be fired for any reason or no reason, okay, as long as it's not an illegal reason. Hey, your bad haircut bothering the heck out of me, you're fired. And that's really not an illegal reason. So things are so strong for the employer. You've got to be pretty sure of proceeding on an employment case. Incidentally, I think I was the 5th or 6th lawyer representing Susan Hoyt. We were the ones that took it to trial. I don't think anybody wanted to because they were shying away from it. Target Stores was vigorously defending. They went to a big law firm, spent all the money they needed to for that vigorous defense.
Thank you and congratulations.
Thank you very much.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.